Hello, everyone. Happy New Year from your UPC Insights crew, and welcome back to the first show of the 2026 year. I'm your host, George Walden, and today we're excited to have our first guest of the year. But before I introduce our special guest, I want to give our listeners a little background on our first guest of the year. His name is Mr. Niels Schuh. Niels advises national and international clients on all aspects of intellectual property law. The focus of his work is on advising and representing clients in national and cross border patent infringement and related validity litigation, in particular in the fields of telecommunications, electronics, and mechanical engineering. And when it comes to standard essential patents, he's also advises on competition law aspects, so called FRAND defense. Ladies and gentlemen, without further ado, Mr. Niels Schuh. Niels, welcome to the show.
Hi, George. Thanks for having me on your show.
Well, thanks for being here. Thanks for taking a little bit of time out of your busy schedules. So we'll get right into it on this first podcast of the 2026 year. It's going to be about claiming damages at the UPC. What possibilities, Niels, for a patentee as a claimant exist for requesting damages at the UPC?
Overall, two possibilities for claiming damages under the UPC exist.
Okay.
As the first possibility, a claimant can claim damages in main proceedings as a final decision. As a second possibility, and different to, for example, German proceedings,
Mhm.
an interim award of damages can also be granted in main proceedings. However, this award is, of course, an interim award.
Okay, meaning that it's not the final decision, or?
It's not, well, it's some sort of final decision, but it's not the final determination of the amount.
Okay, interesting. So, what are the possibilities for asserting the claim for damages in main proceedings? That'll be interesting to hear.
Well, the rules of procedure allow, in the context of infringement proceedings, that the amount of damages is set, whereby the amount of damages is immediately stated in the first judgment. This
Hmm.
presupposes, of course, that the claimant has sufficient information for calculating the damages prior to filing the action. Well, usually this is quite difficult because you do not have sufficient information about
Hmm.
the scope of infringing activity. Thus, the standard way for claiming damages is different. The claimant can file an action for patent infringement, then the court can establish the existing of an infringement of a European patent and an obligation in principle for the infringer to pay damages.
Hmm.
If this is given by the court, the next step is that the claimant can initiate a separate action for the determination of damages. In this context, it's important that the UPC clarified in its decision 5 versus real that the UPC has a jurisdiction also in the case that a national court has established the patent infringement for determining the amount. So, as a background, that the possibility for cost reimbursement
Hmm.
is way more attractive at the UPC. It might be worth to consider that claiming damages at the UPC is of interest. Thus, it is possible to first file a national action and then potentially have a second UPC action for calculating damages.
So, what would you say if you were to advise the claimant what the best route would be? Which way would go? Does that depend completely on the case, or would you say, in the usual way, the claimant should file an action for patent infringement, or?
So overall, I would this has to be a case-to-case decision.
Hmm.
But I feel like, in particular, in litigation which is going on for quite a few years now, and where national actions have been initiated,
Uh-huh.
it might be worth to consider that you can claim damages at the UPC instead of going to the national courts back.
Okay. Then when is an infringer liable for damages? Now it gets interesting.
The liability for damages is stipulated in Article 68 of the Unified Patent Court Agreement.
Okay.
Person to Article 68, the court shall, at the request of an injured party, order the infringer who knowingly or with reasonable grounds to know engage in patent infringement activity to pay the injured party damages appropriate to the harm actually suffered by the party as a result of the infringement.
Okay.
Well, that's a lot of information. So let's break it a bit down. In the first step, the infringer has to know or must have reasonable grounds to know that he's engaged in patent infringement activities.
Mm-hmm.
In its decision of December 9th, 2025, in the so-called Earlycon decision, the Court of Appeal of the UPC provided guidance on the interpretation of Article 68. As an in the decision, the Court of Appeal argued that as an active stakeholder in the industry, the infringer in this case was at least reasonably expected to monitor the patent landscape before exhibiting its product on the market and should have had reasonable grounds to know about the existence of the patent and infringement. Failing to do so was considered as a negligent. Well, the reasoning of the decision refers to the fact that the party involved considered itself in the proceeding as an international leading manufacturer of the industry in dispute. Thus, even by the wording of the infringer itself, he must have been expected to monitor the patent landscape. However, it is likely that the reasoning will also not only apply to the so-called big players or international leading manufacturers, but to likely very much all parties, irrespective of the size. Summarized, the cases where no liability to pay damages for patent infringement exists appear to be very limited.
Is that normal in that situation, or is that something?
That's pretty much in line with the, for example, the German standard that parties who enter a market are expected to know of the be aware of the patent landscape.
Okay.
However, there's a difference, at least to the current status of case law. Under German practice, an infringer has 1 month after the publication of the grant of the patent to be aware of the patent and assess the potential infringement.
Okay.
After this month, they are liable for damages. Under the UPC and also in the mentioned decision of December 9th, the case law did so far not clarify if the same standard applies or they are liable straight away from the publication of the grant of the patent.
Right. So then what kind of damages can be claimed?
When calculating damages, the court has to take all appropriate aspects into account, person to Article 68. Article 68 stipulates the following aspects as appropriate. First of all, negative consequences, including lost profits,
Right.
then unfair profits made by the infringer, and in appropriate cases, elements other than economic factor, such as the moral prejudice caused by the injured party by the infringement.
Okay.
According to the wording, lost profits by claimant and unfair profits can be claimed at the same time. However, there's no decision so far, and we will have to see how the court will interpret Article 68. At least under German practice, claiming both would not be possible.
Okay.
In the mentioned decision of December 9th, the infringing the case was about an infringing embodiment presented at a trade show, whereby the trade show was considered to be very important for the industry. In addition, some statements were made indicating the importance of the trade show by the infringer and the infringer's presence there. In this context, the Court of Appeal did not consider this case as relevant for reputational damages. Furthermore, the court just said that those general statements and the presence at the trade show cannot establish a reputational damages. As a second possibility, if you the UPCA allows also to request a lump sum on the basis of elements such the amount of royalties one has to pay. This is, of course, of more interest if the profit by the infringer is very low, but a license fee can be higher. And will also be easier to claim in proceedings.
Do these standards also apply for the interim award of damages?
Under Rule 119, it is possible to claim an interim award of damages. However, the interim award of damages is calculated different from what we discussed.
Okay.
Pursuant to Rule 119, the court may order an interim award of damages to the successful party in the decision on the merits, subject to any conditions that the court may order. Such award shall at least cover the expected cost of the procedure for the award of damages and compensation on the part of the successful party. Thus, it is important to understand there are two factors which are relevant for claiming the interim award of damages. On the one side, it is if you indeed want to claim damages, then you can set an amount of interim award of damages.
Okay.
This would apply to the standards we discussed a few minutes ago. The second intention of Rule 119 is that a party establishes the infringement of a European patent, and as a next step has to initiate second proceedings for claiming the amount of damages. And the interim award of damages shall at least cover the attorney's fees, the recoverable costs are attorney's fees and court fees. So this would this amount for claiming the amount of damages would be covered by the interim award of damages.
Okay. Then that's kind of interesting. I mean, what's your experience though from your proceedings in courts? Which is more likely for the defendant or the claimant to come out successful in? I mean, is this normal that you would get most of your attorney fees covered by the court? Obviously, if you win or whatever the case is. But I mean, from your opinion, or
so it's of course possible to grant an interim award of damages, but it's but so far the decisions there's no clear view of the UPC so far.
Right.
However, from the decision which are published, it can be seen that the claimant on the one side has to give good guidance why such an amount for the interim award is needed, and it cannot just speculate about some details or aspects he might be worth to consider.
Right.
So here in the decision so far, for example, the table which provides a ceiling for the cost of recovery, the ceiling for recoverable costs had been used as an argument that this amount will later be also needed for claiming the amount of damages. On the other hand, there are some decisions where the defendants have not really disputed the suggested amount by the claimant. In these cases, the court was generous and granted higher amounts of interim award. However, there's no decision by the Court of Appeal so far, so we are expecting there some guidance.
Yeah, but that's pretty interesting. I mean, so I think taking it from, we've had a couple of weeks break basically for the holidays with the UPC courts, so things are going to get started rolling pretty soon in the next year. And this is pretty interesting. So, Niels, I would like to thank you for taking the time out of your busy schedule to join us on the show. And to our listeners, we would like to thank you for joining us for another episode of UPC Insights. We look forward to bringing you all the latest developments in the world of UPC Insights. Feel free to check out our past shows on YouTube or Instagram as they are more relevant than ever, or check out our UPC Insight shorts with the legendary Tillman Frank. My name is George Walden on behalf of Niels Schuh, and I wish you a wonderful start to the new year. Stay tuned for our next episode on the UPC Insights. Until then, for Niels and me, auf Wiedersehen.
Wiedersehen.
Ciao, guys.